Baxter Professor of Law at Brigham Young University Law School. Mr. Alexander Vilexanin, Head of the International Law Program, University. Professor Chao Yi Jiang, Junior Associate Professor of Law, Fundang University Law School. Mr. Rafael Parra Perea, Leader in Personal Data Protection in Grupo Gloria, Peru. And Mr. Ori Thompson, formerly Assistant Legal Advisor for Cyber Affairs, International Law Department, Israel Defense Forces. Without further ado, we give floor to the Chairman, Mr. HUANG Zhixiong.
Professor Yi, would you please say something?
Sure, thank you. Excellencies, colleagues, and friends, when the Chinese Society of International Law received the invitation from the organizers to organize a plenary roundtable on the international law of cyberspace, we could see that the choice of this topic for the plenary roundtable on the first day of this meeting reflects the importance that the organizers attribute to this topic. The Chinese society shared this view and immediately accepted the challenge of organizing this roundtable. The president of the Chinese Society, Professor Huang Jing, soon organized a small coordinating group in order to promote debate on the important issues. We identified six subtopics, namely developing countries and cyberspace law, NATO perspectives, Russian perspectives, Chinese perspectives, state responsibility, and evidential standards. And we quickly rounded up an excellent group of 6 scholars to make presentations. They come from all of the major players in cyberspace. They have done great work in the field, in practice, research, or both. Today, some are present on site with you, while others will participate through cyber channels, appropriately for this roundtable. Now I have the pleasure to introduce our chair of the roundtable, Professor Huang Jing. Dr. Huang Jing is Professor of International Law and former President of China's University of Political Science and Law. He also serves as President of Chinese Society of International Law, President of Chinese Society of Private International Law. He is currently a member of the Permanent Court of Arbitration, in addition to being an arbitrator of a few other organizations. He was among the first group of honorees recognized by China's top 10 outstanding young jurists. It's a great pleasure for me to invite Professor Huang to take the chair. Professor Huang, you have the chair.
Thank you, Professor Yi, for your introduction. Dear Ambassador Oscar Bauta de Romena, Executive President of Third World Meeting of International Law Societies, Professor Alan Palais, Honorary President of the Third World Meeting of International Societies, Excellencies, colleagues, friends, welcome to our plenary roundtable on the international law of cyberspace, state of the situation and the required developments. We first extend our heartfelt thanks to the organizers of the Third World Meeting of International Society, especially the Peruvian Society of International Law, for inviting the Chinese Society of International Law to organize this roundtable on the most important topic. We have invited an excellent panel of speakers for our roundtable. The panelists and their subtopics are as follows. The first speaker will be Professor HUANG Zhixiong. He has been professor and the Westing of Wuhan University Law School, China. More importantly, he has acted as the special reporter of Cyberspace Law Working Group of the Asia African Legal Consultative Organization. He will speak on developing countries and the international law in cyberspace. The second speaker will be Professor Eric Jason. He's a Robert W. Baxter Professor of Law at Brigham Young University Law School. Previously, he has served as special counsel to the Department of Defense General Counsel. He will speak on NATO perspectives on the international law of cyberspace. Our third speaker will be Professor Alexander N. Winegzani, the head of the International Law Program, MGIMO University, Russia. He has been a distinguished scholar in Russian in the field of public international law. He will speak on Russian perspectives on the international law of cyberspace. Our fourth speaker will be Dr. Jiang Chaoyi. He's a junior associate professor of law at Fudan University Law School, Shanghai, China. She has done significant research on the topic, and the title of her presentation will be Decoding China's Perspectives on Cyber Warfare. Our fifth speaker will be Mr. Nafir Palaparia. He is a leader in personal data protection in Grapo, Gloria, Peru. Previously, he has held a lot of positions in cyberspace matters. He will speak on state responsibility in cyberspace. Our final speaker will be Mr. Ori Pomsen. He was a former assistant legal advisor for cyber affairs, International Law Department, Israel Defense Forces. Currently, he is a PhD candidate at the Faculty of Law in Cambridge University. He will speak on eventual standards in international law of cyberspace. I just want to mention that I hope speakers to pay more attention this point. I would like to remind the speakers that each will have only 9 minutes to make your presentation. 9 minutes for your presentation. Now, I have the pleasure to invite Professor HUANG Zhixiong to take your microphone to speak on the developing countries and international law in cyberspace. Please, Professor Huang.
Okay. Thank you, President Huang and Professor Yi. And hello, everyone. It's such a great honor for me to be invited to this important event, although it's also a great pity that I cannot attend in person. Can I share my slides? because here I see I'm not allowed to share the slides. Is it a technical problem? Because, okay, now I think I can do that. Yeah. Can you see my slides?
Yes, we can see it.
It's possible to see.
Okay.
Yeah.
Okay. So my presentation today will be divided into 3 parts. 1, clarification, 2 sets of statistics, and 3 observations. As there's no universal or standard definition for the term developing countries, and much of my analysis is based on statistics regarding developing countries' performance in the field of international law in cyberspace, it appears necessary for me to clarify at the outset the relevant terms for the purpose of my presentation. It may be helpful to begin with the term developed countries and membership in the Organization for Economic Cooperation and Development, or OECD, is often used as a starting point. Although among the current 38 member states of the OECD, whether countries like Chile, Colombia, Costa Rica, and Mexico can be properly categorized as the developed countries is debatable, I think it is safe to say that of the 193 members of the United Nations, only 30 plus are developed countries, while most others are developing countries. Also, it's important to note that within the broad category of developing countries, significant differences exist. For example, between the so-called emerging economies and those least developing countries, least developed countries. So, with this in mind, I now move to my second part. That is 2 sets of statistics regarding performance and the performance of various countries in the field of international law in cyberspace. The first step is the participation of different countries in the UN group of governmental experts on information security, also known as the UNGGE. As many of you are aware, from the year 2004 to 2021, a total of 6 groups of governmental experts had been convened, and that forum constitutes the single most important international stage for discussing and negotiating international rules for cyberspace, at least by the year 2021. The number of members or governmental experts in the UNGGE, in each UNGGE, increased from 15 to 20 and then to 25. For the 6 GGEs, there were altogether 115 members from 44 countries. The table here shows how frequent those 44 countries were involved in the GGE process, because you can see a number of countries, 19 countries attended only once, while 6 countries, China, Germany, France, Russia, the UK, and the US, attended all the 6 GGEs. So among the 44 countries, my calculation is 18 were developed countries. That is near 41%. 5 were BRICS countries. That means Brazil, Russia, India, China, South Africa. That is a bit more than 11%. And 21 were other developing countries. That is less than 48%. This is one percentage. With regard to the percentage in terms of number of members among the 115 in total, we can see 57 were from developed countries. That is near 50%. 25 were from BRICS countries, more or less near 22%, and 33 were from other developing countries, about 29, near 29%. This is one set of statistics. Then the other set, the elaboration of national positions on international law in cyberspace. As international law in cyberspace is still in a burgeoning stage at the very beginning, the articulation of national positions marks a vital step in shaping future international rules for cyberspace, including the application of existing international law and the formulation of cyber-specific new customary international rules. As those national positions may well constitute state practice and opinion juries in cyberspace. So from the perspective of which states have released their national positions and what the legal quality of such national positions is, countries can be roughly divided into 3 groups. Group 1, around 26 Western countries, which have submitted their position papers to the UNGGE or the subsequent OEWG, the Open-Ended Working Group, or separately articulated their positions with relatively detailed and carefully reasoned legal arguments. Then the second group, around 7 non-Western countries, which have also somehow articulated their positions, but with relatively short and poor legal arguments. And finally, group 3, other countries, mostly non-Western countries, which, at least to my knowledge, have never or rarely publicly expressed national positions on international law in cyberspace. Now, the third part, 3 observations based on the two sets of statistics above. Number one, it appears that quite unfortunately, in the field of international law in cyberspace, countries have been divided into three worlds based on their participation and the influence. While the 30+ developed countries, which are in a leading position, fall into the first world, and a few developing countries, mainly the BRICS countries and several other emerging economies, which are trying to catch up, fall into the second world. Most other developing countries, which simply cannot effectively participate in and influence the international lawmaking for cyberspace, belong to the third world. Number two, the current division of the three worlds has become a major obstacle for international order and the rule of law in cyberspace. We know a butterfly flaps its wings in Brazil or here in Peru, and then subsequently a storm ravages half of Europe or the United States. In the interconnected cyberspace, the interdependence among countries has risen to an unprecedented level. So let's not forget that the I love you virus, which swept the world in just a few days and caused the loss of trillions of dollars in the year 2000, in the year 2000, initially originated from the Philippines. And in the end, that country was unable to punish the perpetrator due to lack of applicable domestic laws. So as we discuss the development of international law in cyberspace, the vast majority of developing countries simply cannot be left out. Instead, they should be given the chance to meaningfully participate in international lawmaking for cyberspace and allow their interests and concerns to be better reflected in this process. And number three, to my last point, to change the status quo, effective capacity building for developing countries are badly needed. Cyberspace is such a novel and complicated domain that only countries with sufficient technical and legal capacity can effectively participate in and influence the international rulemaking process. So, but for the huge number of countries simply without the necessary capacity to articulate their national positions, capacity building in this regard will be essential. In doing so, all the other countries should bear in mind that to help others is to help ourselves. So with this, I conclude my discussion on developing countries in the field of international law in cyberspace. And I thank you for your attention. Thank you.